All right, Jenna.
Hi, everyone. Thank you so much for joining us for our Justabout Education webinar about hot topics in estate planning. We have the best out in charge of it. Chuck Hadad is our special guest here with us, and he's going to go over all the things that you need to know. And then towards the end, we're going to do a Q&A for any unanswered questions that you may have. So now I will take it over to Dave to give the introduction.
Hello, everybody. Thanks for coming on. We really appreciate it. Thank you to Chuck for being here. One thing of note before I talk about Chuck, also, if you have any questions in the midst of this that might be, it might be a good time to ask them while we're talking. Feel free to put those in the chat feature. But so Chuck Hadad. So I think the most famous thing about Chuck Hadad is that he and I went to the same high school. We didn't go at the same time. We did live very close to each other. Knew of each other, but didn't know each other back then. And we joined a group called Vistage that we were in together for a while. And then lo and behold, we actually moved in, Justabout Wealth moved into the same building that Chuck's law firm is in here in South Point. They also have another office up north. So we see a lot of Chuck around the office, and I have to jump out of the way of his truck when he's driving into the parking lot sometimes here, but it's all good. Chuck, Chuck is definitely an expert in estate planning. I'll give you a little background on him. He went to Pitt for his BA. He got his JD with honors from the Thomas M. Cooley Law School in Michigan. He also got a certificate of merit in estate planning while in law school. He's a partner and the chair of the Estates and Trust Department for Lynch Law Group. And, I've worked with Chuck in the past with some clients, and he's done a great job with some very difficult cases that I've sent his way. So I have a lot of faith that he can do a great job and that he can give everybody a lot of great information. Another thing that I might be stealing his thunder about is if you go to his bio on his website, there are a whole bunch of YouTube videos about a lot of different topics, estate planning topics. So you can definitely, if you want some more information, you can definitely go there as well. But hopefully we'll give you some great information here. And maybe if you have any other questions, you certainly can let us know. You can reach out to Chuck after the fact as well. So Chuck, take it away.
Thanks, Dave. First, I just want to thank Dave and the whole Justabout Wealth Management team for giving me the opportunity to speak to you guys this evening. Hopefully everybody can hear me okay. If you can't, feel free to mention it in the chat. I'm a little soft-spoken, so sometimes I get that comment, but I will yell if I need to. I want to make sure you guys get some great takeaway information. As David mentioned, we've known each other for several years, and we're now, stars have aligned, we're in the same building. So we see each other quite a bit, and we work and collaborate on a lot of different planning topics. I'm gonna kind of go over, I'm gonna keep this somewhat informal. I'm gonna do a lot of speaking. I'm not gonna give you like an outline. We do have a takeaway handout that will go over some of the foundational documents that you guys probably have in your email with your link. But I'm basically gonna go over to the different hot topics that are coming up in estate planning. I'll start out with some of the basics, and then I'll roll into some of the more, what I would say specific, not so much complicated, but specific issues that you should be aware of that may be part of that impact part of your goals, and some may not. It might be something, a seed for the future that you have to think about from your planning needs. I always start out with, what is estate planning? A lot of people sometimes can get confused. They think it's, I just need to get a last will and testament and that's it. My mom and dad had a will, I need a will, and that's an important piece of it. But typically your foundational estate planning documents, I always say foundation because every plan needs the foundation and you can build off of it. So those foundational documents are not just a will, but also there's 3 documents that help you while you're alive. And one is a financial power of attorney, one's a healthcare power of attorney, and one's called a living will, or some states call it an advanced healthcare directive. Now, those might seem obvious, but it's really important to have all of those foundational documents in play. and to make sure that those are updated properly so that your key decision makers in your plan are properly aligned to your planning needs. So if something would happen to you, for instance, if you became incapacitated and you were unable to make your own decisions, those financial powers of attorney are really important. So your loved one could stand in your shoes and make your financial decisions. That can even be done from a convenient basis if it's just too much on your plate at some point in time in life. It's always important when you're doing your plan to have an initial, but also a backup to who you're deciding to put in each of these roles. Sister document to that is a healthcare power of attorney. And a living will is really end of life decisions. So pull the plug, deciding whether or not you want a tube feeding. Really the main thing is making sure your wishes are shown on paper. So it's not a question mark. You know, if you don't get that opportunity to talk to your loved one on what types of care you want and what you don't want, if you're ever in an end stage or terminal state, that's where that living will is very important, because it will give a guide. And in some cases, if you elect it, can also control and make sure that your wishes are met throughout that process. Hopefully that's a minimized process, and maybe, you know, it's the toughest part of life is what I say. But those three documents are really important. I'm just going to touch upon them in this conversation, but they avoid a guardianship. And a lot of people are concerned later in life, if they don't have these documents, what happens? Typically, a guardianship can trigger. And that's a hot topic in estate planning, because if you do not have a plan, that's in essence what you're going to do. You're going to rely upon the court system, which is very involved. You know, your typical, and they call it plenary, which means permanent guardianship in Pennsylvania. I'm just using Pennsylvania as an example. Every state will have their own process, but it's usually 90 days to get a guardian permanently appointed through the courts. And you have to depose a physician. You have to have medical evidence presented. And then that person's legally stripped of their right to make their own decisions in order to have that guardian appointed, which is a pretty tall process. And it should be, because they're stripping you of your rights legally to make decisions. And that can all pretty much be sidestepped with a power of attorney. So even though it sounds like a basic planning document on its face, it's really, really important to have that in place. But post-life goals, you know, everybody thinks of a will, and that's really important to have, and that's the foundation. So that's like the start. If you don't have a will, there's something in Pennsylvania called intestate statutes. So Pennsylvania writes your will basically if you do not have one. And I always like to throw this out before we go into more advanced documents, because it's really important to have at least the basics in place. Because if you don't, more often than not, the goals that you have in mind on who gets what when you pass away is not what Pennsylvania has written in their statutes. I'll give you an example, and you can't really judge a book by its cover, because I have a laundry list of celebrities that I'm going to read off real quick that did not have a will. So we're talking high net worth individuals. Okay. Prince, has anybody heard of Prince? He didn't have a will. Bob Marley, Aretha Franklin. Okay. Michael Jackson had a will, but it was in disarray, so it was in litigation. It still is in litigation. Amy Winehouse, Kurt Cobain, a lot of these are musicians. Maybe they didn't have their act together, but in any event, these are all very high net worth individuals. And believe it or not, I will vet this even further, but Abraham Lincoln did not have a will. So it's an interesting note, but I will tell you guys, when you're relying upon intestate statutes, I will tell you one of the big misconceptions is everybody thinks if I die married, that my spouse is going to get everything. But unfortunately, under Pennsylvania law, and I will tell you pretty much every state across the board follows this pattern, only a piece of it goes to your spouse. Okay. So in Pennsylvania, if you have children, essentially, and there's the same children as your spouse, the first, meaning you share those children, the first $30,000 will go to the spouse, and then the rest will get split, half to spouse, half to children. So that's a big issue with a lot of individuals out there, regardless of their background, because if they intend to leave everything to their spouse, vice versa, they need a will to do that. They need to make sure they're connecting the dots on their planning goals. So, you know, intestate statutes can even go further to connect your family tree, some of which you may not want to receive an equal share, particularly if you get all the way down to the sibling class. We see a lot of issues in the intestate statutes in Pennsylvania when you get to that class, because maybe it wasn't an even Steven approach. So I just wanted to mention it because I'm not going to go into detail on the intestate statutes. I just want you guys to be aware, if you don't have a will, something as basic as a last will and testament, it's really important to have just the foundation, because it avoids those big issues that can come up by just not having anything. And not having a plan is actually a decision. Okay, a lot of people think, well, I don't have to decide. Well, you're actually making a decision by not having a plan. Okay. So those are the foundational documents. Your last will and testament typically will have provisions that go over what I call the who, what, when, where, why. Okay. Who gets it, when they get it, why do they get it? I will tell you, when you're developing and monitoring your estate plan from a goals standpoint, I try to digest it as simple as possible. Most plans should have like 4 layers of your goals. Okay. So when you're thinking about your planning needs, what happens at each of the layers in your goals, hypothetically. We go an extra step, not just when you pass what happens, but what happens at the next layer. If the person who, after you answer that question, what happens when you die, who gets what, okay, well, let's look who's on that list and what happens if they're not there. Okay, now that's the second layer. So if you go 3 to 4 steps down, now you're starting to build a more cohesive plan. And it's really important to think about that as life goes on, because the other hot topic is a lot of people think once I have a plan together, that's it. I don't have to ever look at it again. It's done and I'm set for the rest of my life. I will tell you, it's a moving target. Okay. Family life goals change. People come in and out of your family that impact your plan. People that you might have had involved in your plan in important roles like powers of attorney, executor. I'm going to talk about trust here in a moment. They're really, really important roles. And if something happens to them, that impacts your plan. So it's a moving target. It's really important to get in the habit to take a look at it every couple years, and at minimum when those life planning issues come up, so that your plan is customized, but it's current. Okay. And laws can change. So one of the things my team does, and I know Dave does really well as well, is we get these these recent changes, these hot issues that come up to the forefront, so that you can make informed decisions and whether or not that impacts your plan. Sometimes it doesn't. Sometimes it might just be a small tweak, and sometimes it actually might have a major impact. So I'll talk about a couple changes in the law recently that might have an impact to your plan. But that foundation, I can't stress it anymore, it's really important to have it. And I can tell you, you can't judge a book by its cover. I handle very simple to very complex plans, and I've had clients that have had $30–40 million valued companies with no plan at all, because they're worried about payroll, they're worried about running their business, life goes on, and you know, they kind of think they're bulletproof, so to speak, immortal, and before you know it, something can happen and a mess is kind of left behind. And the plan is really to smooth the process, to make sure that transition occurs very smoothly to the people that you trust. And a lot of estate planning is family planning, okay? Probably 90% of it. I'm gonna talk a little bit about the tax planning side too, but I call that the icing on the cake, because I think that I'm a numbers guy, and I think the tax planning is the easy part of estate planning, because the harder part, in my opinion, is making sure the family dynamic all works smoothly, okay? And the goals, sometimes that's philanthropic as well. So I'm going to move into how you build off that foundation now, okay? So to kind of talk about that a little bit, probably the most common planning tool that's used as kind of like the next level to an estate plan, that's what I would call a hot topic. It's not new by any means, but it's always a hot topic, is whether or not I should consider a revocable trust, okay? So a revocable trust is really what I would call an organizational document, okay? A lot of people think the word trust provides it all these bells and whistles, so that when you create it, for instance, one big misconception is they think it saves you on taxes. Okay, if I put everything into a revocable trust, I'm not going to pay any more taxes. Well, that's a big misconception, because if you control it and you can change it, it's just like you. It's just like an individual account from a tax standpoint. Okay, but the big benefit to a revocable trust is it allows you to organize your assets so that you can sidestep some adverse issues that can pop up with an estate. And one of them is called probate. Okay, so some people think it's a dirty word. I will tell you, it's not a dirty word. Probate is a process. Every state has their own process. Pennsylvania's pretty streamlined, but I will tell you, even in a simple probate, there's going to be some delay. You're going to have to go through steps to get from point A to point B. So, for instance, in Pennsylvania, if you have an asset solely owned that's worth over 50K in value, over $50,000 in value, and it's solely owned with no beneficiary on it, you will have to go through probate in order to clear that title and transfer it to your beneficiaries, whether that's under your will or, if you didn't have a will, intestate. So it sidesteps that process and allows it to go from point A to point B without being hung up with that delay. Some of that delay requires, the probate process will require advertising, an inventory that's public record, court costs to open the estate, to file an inventory of what you own solely in your name. And when you have real estate involved in your plan, can really slow down the process. Sometimes it can take 18 months, 24 months to get through. So one of the big benefits to a revocable trust is it allows you to kind of organize all your assets so that you can sidestep that. Not only for your home jurisdiction, so say I live in Pennsylvania, but say I have a house in South Carolina or Florida or in another jurisdiction. It will, as long as I align my assets properly, entitle them in accordance with the trust, essentially it will avoid probate in your home state and also any jurisdiction that you own real estate in or foreign jurisdiction. So it can basically give you that streamlined approach. The other benefit is confidentiality. So confidentiality comes along with avoiding probate because your assets are not going to be on public record. So, you know, when you file that inventory with the county row house or your executor does, it lists everything that's in the probate, every value as of date of death of those assets. And that might not sound like a big thing, but I will tell you, it kind of gives a road. And it also gives a roadmap if people are looking for information on who's inherited wealth. Okay. Well, who looks for that? All kinds of organizations do, because they're looking for target markets, basically. So keep that in mind. And the costs of probate can be high depending on your jurisdiction. I know some other states have very high probate costs statutorily. And attorney fees, typically you're required to have an attorney. In Pennsylvania, they'll let you in some jurisdictions get around it, but I will tell you, most jurisdictions are going to allow or are going to require you to have counsel, which is going to add potentially to those costs. And you still should have counsel guiding you through any administration, even if it's not probate, to transition, but that becomes minimized compared to a probate process that might have a lot more fees and costs involved. The cost to set up a revocable trust sometimes are more involved, obviously, than your foundational plan. That's one of the cons to it, but you kind of have to compare apples to oranges a little bit here, because if you're, in my opinion, if your net worth is starting to get into the 7 figures, that it usually puts you in a more efficient plan to have a revocable trust structure. But it's got to fulfill a goal. It's got to fulfill your goals and make sure that it can transition properly, because you can avoid probate with proper alignment as well. Like Dave and I talk a lot about making sure your assets are titled properly, whether it's joint or they have a beneficiary designation on them. It is so important to go through those beneficiary designations to make sure they're current, particularly when there's any change to your plan. Okay. So if you update your plan in any way, that's going to impact your beneficiary designations. Well, what are those assets that you usually have beneficiary designations on? Commonly, it's going to be things like life insurance, retirement assets, any type of qualified account. Roth IRAs, traditional IRAs. At work, if you have 403B, SEP IRA, or 401ks, those retirement employer-based plans essentially are going to all have beneficiary designations on them. And I will tell you, more often than not, one of the big hot topics in estate planning is not putting down the right beneficiary designation or updating it properly. I mean, Dave, how many times do we see when we'll be introduced to a client, we're going over the list, we're like, did you mean to not put a contingent beneficiary on this? Or is this who you prefer to name because it's not aligned with your other designations? And usually it's whoever they listed when they got the job or when they, acquired that asset initially, and they hadn't looked at it since then. And life gets in the way of these things. That's where these issues arise. But it's really important to be prudent when you're updating, to do a thorough look, because that's all part of the estate plan. Okay.
Yeah, we've had clients who had ex-spouses still as beneficiaries, or they have more than one child now and they only have one kid on there as the beneficiary and things like that. Chuck, I wanted to touch on something with you. Some of our clients who don't have joint accounts, for example, with spouses, sometimes we do a transfer on death. So, in terms of, if a client doesn't have a whole lot of, assets to put in a revocable trust, can transfer on death be a good way to go?
Absolutely. So transfer on death, some banks will call it payable on death. Okay. Some institutions, it's really important to make sure that you review those types of options, because that's an easy way to make an asset and take it from probate to non-probate. So the term non-probate just means it doesn't go through probate because of the titling. So like Dave just mentioned, if you change your signature card on that asset or you update the registration, for instance, with Dave, and add a POD or TOD on that account, what that does is trigger something called the Multi-Party Account Act in Pennsylvania, as an example. In that account, upon your death, will automatically go to the designee on that registration. And all they have to do is provide a death certificate, and the registration will change. Okay. There's still tax, though. I want you guys to know that. So you don't get around the tax just because it's POD or TOD. Okay. But very, very, very good point. Joint accounts. If it's husband and wife, you know, if you have a jointly titled property and you reference husband and wife on the deed, that's going to automatically transfer with what's called tenants by the entireties language in Pennsylvania. In most jurisdictions, that's pretty much the same. It's the only way that it's a special type of titling. Technically, both spouses own the property as one. Okay. If you're jointly titled and you're not married, it needs to have on real estate something called with right of survivorship. Okay. If it just lists both names, that's a big misconception, I will tell you. There's a lot of people that get into real estate investment and they'll just say, oh, put both of our names on it. They think it goes to survivor them just by putting your names on it. If it does not have right of survivorship on it, most jurisdictions are going to default to something called tenants in common. And that means each person owns half. So if you pass, your estate will receive half of your ownership in that property. And you can see how that could cause some issues. For instance, if it's a whole different, maybe that's intended, but it's really important if you're planning with real estate to make sure the titling is the preferred way. If you want it to transfer automatically, it needs with right of survivorship language. Joint titling on accounts, like liquid accounts, like bank accounts, brokerage accounts, that will allow that transfer to occur automatically as well. The surviving owner will be deemed the recipient, okay, or the beneficiary. But that, I wanted to stop there for a minute to go over that designation, the customized designation, because that is really, really important piece of your estate plan. Making a list of your financial assets and connecting the dots there, okay? Making sure they're titled appropriately, that the designations have been updated. And when you acquire a new asset, making sure it falls in line with your current plan, okay? And when in doubt, don't hesitate to contact Dave. He's an expert at this. So without a doubt, we can guide you. He can guide you and make sure everything's bundled appropriately. Okay. A lot of people think, well, you had mentioned revocable trust. What does that mean? And how does that compare to any other type of trust? Well, revocable just means you can change it. You can amend it at any time, just like you can with your will. Okay. You can modify it. As a result, anything you title in it is part of your estate for tax purposes. Okay. There's another type of trust that's sometimes utilized in planning. It's called an irrevocable trust. So what that type of trust basically means is once you establish it, you can't change it again on your own. Now, a lot of states will have statutes that govern how you can and cannot change an irrevocable trust. You would think by its title, you could never change it again. But I will tell you, a lot of jurisdictions will allow you to change it as long as you follow the rules. And the rules under the law will require more than your signature. For instance, in Pennsylvania, if you create an irrevocable trust, you could change it as long as the people you've named in it as either the trustee, the person who's governing it, and the beneficiaries of it currently, meaning the people that are benefiting after you establish it, and then anybody you've named in the remainder section they're all combined, called qualified beneficiaries under the law. And if everybody on that list, including yourself, all agrees, you can change it. Okay. But where a lot of people will fall into an issue is if someone on that list passes away or isn't in agreement. Well, that's where it's going to have a lock. Okay. The benefit to an irrevocable trust is it will provide what we call creditor protection. Okay. And it's kind of like parking assets on an island, and it has protection on it. Okay. Most state plans can also provide irrevocable trusts as layers to them, meaning your will can create something called a testamentary trust, which is the same thing as an irrevocable trust, but it only triggers upon your death. Okay. And then your revocable trust can convert into an irrevocable trust when you pass away, meaning nobody else can change it. You can change it all the way up to your death. And then when you pass away, it locks in. The benefit to that irrevocability, again, is nobody that you've named in the document has full control. And you might think of control, well, that's a great thing to have, yes. But in the estate planning realm, when you're thinking of when is an irrevocable trust appropriate, usually it's appropriate when you're trying to provide protection. Okay. And who are those types of things that you would protect from for your beneficiaries? One of them could be their spouse. Okay. That's a hot topic. Like if I'm worried about my son going through a divorce or my daughter getting married and going through a divorce. Okay. After they inherit from me. Another one is civil protection. So if they get in a car accident, okay, their inheritance that they receive, making sure that's protected. Another one could be a bankruptcy trustee. If they got in a bad business deal, making sure it's protected. So there's ways that you can go through the layers of your plan and look to who is the beneficiary and apply that appropriate protection. And if you are not giving them the money outright and you want protection, typically it's going to involve some type of irrevocable trust provision, meaning they can't change it on their end. Once you set it up and that triggers, either that's upon your death or say it's now you're gifting things to them, that's a way to provide them protection. It's a really also nice tool to utilize as part of your plan to provide something called a bloodline strategy. So Dave and I will talk to clients a lot about bloodline planning. And if you think about, like, if something happened to me, I want everything to go to my spouse or my kids and continue in my bloodline. I don't want it to go outside of my bloodline. Well, now we're talking about rolling these testamentary trusts or trusts created post-death through your generations below you. And that whole goal is basically, if they're not there, it goes to their kids. If they're not there, it goes to your grandkids or great grandkids. That's dynasty bloodline strategy. And you can do that up to a certain extent for tax purposes. Okay. So before I go into additional planning strategies, I want to talk about the taxes a little bit, because I want to give you guys some takeaways. We deal with death tax analysis a lot. Dave and I will talk about, what are the numbers and where do your numbers fit with the numbers related to death tax rules in your jurisdiction. I'm just going to talk to you a little bit about Pennsylvania, but I want you to know there's some other states that have these issues that can arise too. And then I'll talk to you a little bit about the federal. So Pennsylvania has something called an inheritance tax. The tax is triggered when you pass away, and it's considered a transfer tax to the beneficiary. And there's some assets that are exempt, like life insurance, but the rate depends on your relationship from you, the decedent, to the beneficiary. Spouse is 0% in Pennsylvania. Children, grandchildren, we call that lineal. That's 4.5%. Collateral, your siblings is 12. And then if you're outside of those categories, typically Like if you're a niece or nephew, unfortunately, that's going to be in the 15% category. So that's a state death tax, but that's taxed on $1. For instance, some other jurisdictions like New York has one that impacts once you hit a certain threshold of assets. It's similar to the federal rules, but it's not as high as an exemption. I think it's like 2 million. Anything up to 2 million is exempt, but once you get over 2 million, you hit the tax if you're not a spouse. Okay. And the tax rate, not sure what it is off the top of my head, but it's definitely more than 4.5%. But the whole thing I want you guys to know is there could be a death tax there at the state level, in addition to the federal level, depending on where you reside when you pass away. A lot of states across the country, though, disconnected and did away with their estate tax or death tax when you pass away. So we see sometimes change of domicile as a hot topic. So Dave and I will talk about, whether or not if you had a vacation home in another jurisdiction and you started to spend a lot of time there. For instance, if you start spending more than 6 months, it might be appropriate to look at the income tax versus death tax analysis to see if you're in the right state for tax purposes. And that could impact your estate plan because it has to be papered accordingly. That's one of the factors. And it's a hot topic. That's why I wanted to mention it. For instance, if I have a vacation home in Texas, Texas doesn't have a death tax. Okay. For instance, I start spending more than 6 months there. It might be more beneficial for me for my kids to change my domicile or jurisdiction residency at some point in life to Texas as opposed to Pennsylvania. But you got to look at the income tax side too. And that's where Dave's really good at as well. Like, for instance, Pennsylvania doesn't tax retirement income, but some other states do. So it might not be a really good idea, depending on the state where you convert. So if you have another home in another jurisdiction, or you ever intend to winter bird somewhere, that's something to keep in mind, is to review your income tax versus your state death tax. Federally, right now we're at an all-time high. We have a cushion of $12.06 million per individual. Okay. But it's almost like, will the sweet unified credit stay there? So Dave and I talk a lot about some of the current legislation that's really hot topics in the pipeline. And one of them is called a sunset provision. So right now there's about, there's a piece of the law basically says the end of 2025, the way that the Tax Cuts and Jobs Act was implemented in 2018, it has a provision in it that sunsets or expires, and it reverts back to the 2017 laws at the end of 2025. Now, not in all aspects of that tax change, but specifically on estate tax, unified credit. And basically what it means is come January 1st, 2026, if Congress does not extend the current legislation, that 12.06 number will convert back to 5.49 million per individual, okay, plus inflation since 2017. So we might be in the 6-ish range, but I don't unfortunately have this crystal ball that will tell us the exact number. All I will tell you is there's a high likelihood it could sunset if Congress does not do anything in the next couple years to extend that law. And what that basically means is anything up to that number, you pay no federal estate tax. When you go over that number, or if you die with more than that, or gift more than that while you're alive, you pay 40% tax on what's above it. Okay. If you're married, there's something called portability. And this is also a hot topic. So it's really important if you're the surviving spouse to talk to Dave, to talk to your advisors to make sure that you're analyzing whether or not you need to claim what's called portability. So you can claim the first spouse to die's unused exemption. So say your spouse passed away this year, 12.06 million can be claimed and locked in to you, and Congress can't take it away. And it might not seem like a lot because you might say, hey, well, we'll never have that much, but you never know. Okay, when you throw in your home, your real estate, your life insurance, your brokerage account, you throw everything to one pot, it can hit the number, or what the sunset number it might hit. So it's just that extra cushion on top of it. So it's something to keep in mind. There's a couple other topics I want to mention briefly here. One of them is called a Secure Act. So I know we started a couple minutes late, so I'll go a couple minutes long if you guys don't mind. And the Secure Act is basically a new law in 2020 that impacts a lot of retirement accounts. And it doesn't impact you guys directly if you're the participant owner. It impacts your beneficiaries. And there's a lot of rules that were set within it, in addition to what I'm going to talk about briefly here. The main thing I want you guys to take away is there's something called a 10-year rule, okay? And it impacts children, grandchildren, people more than 10 years younger than you that are not of special needs, that are not minors, okay? So particularly, it's going to be your child or your grandchild, which is probably the most common beneficiary other than a spouse. And all it basically means is when they inherit your retirement account, they have to take it all out within 10 years, which can cause a tax impact. There's no longer this thing called stretch IRA. Now the stretch is 10 years, if you think of it that way. And it's important to note, because if you have trust built into your plan that you thought were going to protect your retirement account forever, well, now this Secure Act is throwing a wrench into that plan, because by year 10, those kids are going to have access to that money. Okay. And there's ways that you can minimize that impact in your plan. So I'll mention a few of them. Like one of them that's hot, that picked up a lot of steam, is looking at your plan to determine whether or not a Roth conversion is appropriate for you. Okay. Traditional IRAs trigger income tax when you pull out. Well, when you're on 10-year crunch, if your IRA is your largest piece of your portfolio, think about crunching the withdrawal of that in 10 years. It's really going to push up the income tax over the 10-year period. So if you convert that into Roth when the time is right, with planning behind it, yes, it will incur some income tax, but that can be managed longer term than 10 years. Okay. And it's your kids that will fill this income tax issue. And it sometimes is even comparing income tax brackets. Okay. And bracketing up when you're doing conversions, looking at your income tax bracket, and maybe you have a little cushion to go up and convert a little, go up and convert a little. Because Roth IRAs, when you pull that money out as a beneficiary, you don't pay any income tax on it. Okay, so that's a really big feature. Another one is just making sure your trust language accommodates the Secure Act. I can't tell you how many times I'll pick up a trust and it's an older trust than 2020, obviously, and it might not give the powers of the trustee to comply with the tax code. And it can trigger tax all in 1 year, which, you know, you're guaranteeing to put your beneficiary in the 37% tax bracket. Okay.
Chuck, just interrupt you 1 second.
Yeah.
So just in talking about trust and the language of trust, how often do you see a trust that, you know, you've set up or someone else has set up that is never funded? You know, they do the documents, but they never actually put assets into it.
It happens, unfortunately, a lot. I always say it's like having the Cadillac in the driveway and not driving it, just keeping the cover on it. Or that new pair of shoes that you never want to use, because it's like having the best thing more often than not, but not properly titling your assets. And what it ends up doing is that person intended the right things on the front end, but didn't fulfill it with the follow through. And as a result, they have a mixed bag when they pass away, and some assets go through probate and some don't. So you know, it's really important to make sure on the front end that it's appropriate for you to have a trust. I've also seen people have trusts that don't need trusts. They just need proper titling with their assets and their plan properly implemented through a will strategy. But it's really important to make sure your plan fits you and that there's a follow through behind it, because that alignment piece is just as important as having the documents prepared. Very, very good question, Dave.
Thank you. I don't have any questions in the Q&A right now, so if anyone has any, please enter them. If not, Chuck, if you have some more points, I did have one other question for you.
Sure.
And that is in relation to digital assets. So how are they playing into estate planning going forward?
Yeah, so with digital assets, in 2020, Pennsylvania updated their laws and statutes to accommodate the Digital Asset Act, and basically providing legal authority that you can delegate to a power of attorney, through a will to your executor, through a trust to your trustee, to allow them to control and handle in your best interest assets that might be controlled online, digitally, in making sure that they're not froze out. Okay, because I can tell you before that act, it was like this catch-22. We had, for instance, a client that owned a business, e-commerce online, and they ran their business through their email account. Well, that email account host would not let the power of attorney access the email account because the licensing agreement did not match up and give, they essentially controlled the rights of that account. And they weren't accepting the power of attorney because their host was in a different jurisdiction from where the power of attorney was drafted. And this was pre-Digital Asset Act. So the Digital Asset Act now allows for you to serve that upon and even enforce it upon those institutions if necessary in order to give that authority. But if you think of cryptocurrency, if you think of all these different things digitally that can come up now, online bank accounts, more people are managing their things online than physically. So it's really, really important, and particularly with business, to have the appropriate tailored language in your document. And that's pretty recent. I will tell you, 2020 is Pennsylvania. Pennsylvania wasn't the first, but really, really good question.
We actually do have a few questions now. So one of them is what assets should be included in a trust, house, etc. And I'll include life insurance on that as well. Okay.
So it really depends. It needs to make sense with your alignment. Okay, one. If it's the first thing I look for when I'm aligning a trust after you've established a trust is typically if you have a revocable trust, the whole goal or one of the big goals is to avoid probate. So you want to make sure there's not something solely titled in your individual name with no registration behind it. Like David mentioned, TOD or joint ownership or beneficiary designation. Those will make those assets non-probate. But usually if you want your revocable trust to govern the who, what, when, where, why, it's very common to retitle real estate into a revocable trust. And how you would do that is you would have to have a deed prepared and signed. And it's like you're transferring it to yourself from a tax standpoint. Like in Pennsylvania, we have this thing called transfer tax that triggers when you sell your property or when you convey your property. Well, with retitling real estate through a deed transfer to a revocable trust, there's no transfer tax, it's exempt. Okay. How you would retitle non-qualified, so that's a fancy word for anything that's not in a retirement account. Okay. But those non-qualified assets, you're going to need to retitle the registration. Okay. So the titling on it, it's not going to say John Smith. It's going to say John Smith Revocable Trust, John Smith as trustee. but it will still typically be registered in your social security number. So it won't change your tax prep. But very, very good question. Your beneficiary designated assets, those are usually aligned by updating your beneficiary designations to make sure the language in your trust is linked. Okay.
Next question, talk about gifting while living as a planning tool.
Yeah, so I mentioned the unified credit number was 12.06 right now. So that's your lifetime credit. So you can gift that while you're alive. You can also keep that and transfer that number of assets federally estate tax free when you die. But there's also something called an annual exclusion. Okay. Federally, the IRS allows you to gift a certain number to individuals each year, as many individuals as you prefer, up to a certain number, and they change it they confirm it each year. It just recently changed due to inflation. It increased to $16,000. So in 2022, what that means is I can give, for instance, Dave $16,000, and I don't have to report that to the feds, and it doesn't impact my lifetime number. Okay, but if I give $1,000, if I give a penny more, that penny is going to reduce off of the 12.06.
I think that's a really important point there, Chuck. Oftentimes people think they can only gift up to the maximums of the annual gifting limits. And we tell people, no, you can gift, in some cases, they can gift all of their assets if they choose to do that. They just have to file a gift tax return, in which case they wouldn't have to pay any taxes, but they just have to file that return.
That's absolutely right. So it's called a Form 709. It gets filed the same time as your income tax return. And it's just kind of like running a bar tab on your gifts through your lifetime. And anything you give over the $16,000 annual exclusion comes off the tab. Okay. And the tab starts at 12.06 or what your unified credit is. And you can give all the way up to that without incurring any tax. Okay. So you can accommodate sizable gifts. And that's one of the things that's a hot topic right now. Should I give a big gift while my exemption's high? Well, in order for it to save you in taxes, under the current analysis, typically is you would need to give more than what they might reduce it to in order to have a tax savings. So a lot of people will look at that and they might get a little shell shocked because the sunset amount is probably going to come in around $6 million. So unless you're giving more than $6 million, there's probably not a whole lot of tax savings. We call it go big or go home.
Exactly. Next question, does a trust transfer from state to state?
So it can. So in pretty much every trust, you're going to find a provision that says change of situs. So situs is just a fancy term for jurisdiction. You can give your trustee the authority to change the situs of the jurisdiction if they need to. Well, who decides that while you're alive? Typically, it's the person who creates the trust. That person's usually called a grantor or a settlor. And that's usually you that you're creating it. So you kind of control where it's at. So if you're moving from one jurisdiction to another, to change your trust to a new jurisdiction's very easily done. It's commonly papered with just what we call a simple amendment.
Great. Last question. This is interesting. Are there any reasonable inheritance tax reduction strategies? For example, borrowing from assets to reduce the value of the assets being taxed and paying the loan back later?
Well, it really depends. Inheritance tax, it really comes down to control, in my opinion. You're valuing control versus not having control. Yeah, you can take out a loan and that loan will be deductible when you pass away, but is that going to benefit your beneficiaries in the long run? Because it typically will settle out. Okay. Usually what happens with inheritance tax is it's a snapshot as of date of death. So it's the values of your assets when you pass away. So it's not while you're alive. Okay. And Pennsylvania, they like to throw these strings in the rules. There's something called a look back period. So there's a 12-month look back when you make gifts. So if you make it right before you pass, a lot of people say, well, what if I give my money away while I'm on my way to the hospital? And then a couple of days later, I pass away, no tax, right? Unfortunately, there's a 12-month look back period. So if you can plan it 13 months out, you might time it right. But nobody has that crystal ball. So it really depends, but there are some ways that you can reduce it. I mean, life insurance is not taxable. Okay. So that's a way that you can leverage life insurance to provide, tax-free assets that go to your beneficiaries. And joint titling will minimize, meaning only a portion that the person who died share will be subject to tax. Okay. There's a couple other exemptions like agricultural farms. Another one that's very common is called a family business exemption. So that's pretty new, 2015. There's a string to it though. You have to keep it in the family for 7 years post-death. So, it's not a 1-year string, it's a 7-year string. So if your loved ones sell it, for instance, within 7 years after you pass, they're going to have to pay inheritance tax on it still. Okay. But there are some ways that you can look at your balance sheet. But why I say it controls a factor is most people are paying inheritance tax at 4.5% to their children or grandchildren, not all. And, when Dave and I run like the pros and cons, is it better to give them the asset and save the 4.5% tax, or is it better to keep it and they inherit it? Because one last point I'll bring up is they get a step up in basis unless it's in a retirement account. So that clears capital gains. So for instance, if you gave them a piece of real estate, you gave it to them before you passed, yeah, they might avoid the 4.5% tax. But say you bought that property in the 70s, okay, and the property was worth like 50 grand, now it's worth $500,000. Okay, well, when you die, if they inherit it, they will wipe the $450,000 capital gain. Okay, and the capital gains tax rate, minimum capital gains tax rate is 15%. If you're in that top tax bracket, they will tell you it's like 23.
Mm-hmm.
Okay, so it's like you have to weigh both sides of the analysis before you pull the trigger on that.
Okay, we have one last question to try to squeeze in here. And it relates to gifting, but it also relates to nursing homes. If I gift $16,000 or less and a few years later I'm put in a nursing home, can the nursing home claim that money?
So they can't claim that money, but what they could do is say you try to apply for Medicaid. So when you get into nursing home or what we call elder law, there's an analysis on whether or not you're eligible for Medicaid at a certain point. Medicaid picks up long-term care costs. So that's why this comes up a lot. And in order to qualify for Medicaid, you have to have pretty poverty state, pretty much little to no assets. I think the limit is like $8,000. Okay. But if you made transfers within 5 years of that application, they're required to be disclosed. So the nursing home per se is not going to be able to get that money from the person that you gave it to. They're not going to be able to go to them and say, give me back that money. But the state is not going to deem you eligible because it's going to count against you on your balance sheet to determine whether or not you're eligible for Medicaid. So that's where that factor comes in to the process.
Great. Okay, well, we're going to end there. We're just over an hour. I think this is a record for length of one of our webinars, but certainly a lot of great information, Chuck. I think it was very easy to understand. I can tell you we didn't lose one attendee the entire time. So people must have enjoyed and hopefully learned a lot from what you had to say today. So thank you so much. I want to thank Jenna for the work that she put in on setting this up. So thank you.
You're welcome.
Thank you.
And I hope everyone has a great night. If anybody has any other questions for Chuck, please feel to reach out to us. Let us know what those questions might be. We'll get those to Chuck. Like I said, you can go to, you can look him up. You can go to his website, and a lot of other videos there as well. So thank you, everyone, and have a great night.
Thank you, everyone.
Thank you for your time.